Defense attorneys are typically at a disadvantage in the court of public opinion because they're always playing defense. But what if there was a way for defense attorneys and their clients to flip the script in the court of public opinion and actually take control and lead the news cycle? In this video, I'll tell you how they can do that. Hi everyone, my name is Wayne Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, the preemptive strike. In the court of public opinion, defense attorneys are at a procedural disadvantage. That's because plaintiffs' attorneys and prosecutors typically control the news cycle because they are the ones who are filing the documents in court that make allegations regarding wrongdoing on the part of people who end up being on the defense side of the case. This is very frustrating for defense attorneys and their clients with good reason. Once they are the subject of allegations in a civil or criminal court proceeding, it is difficult for them to ever tell their side of the story. And more importantly, because plaintiffs' attorneys and prosecutors are the ones who are filing these opening type documents, indictments, complaints, etc., they get to frame the legal dispute in the way that most benefits them and their case. But there is a very underutilized way for defense attorneys and their clients to flip the script and take control of the narrative from the get-go, and take the wind out of the sails of prosecutors and plaintiffs' attorneys who are hoping to cash in with some good publicity for them when they announce that a legal dispute or a proceeding has started. Defense attorneys and their clients can do this by making a preemptive strike and going to the media right before they expect a lawsuit or an indictment or some other legal proceeding to be filed against them and their clients. It is the equivalent of attorneys during an opening statement or while they're examining a witness introducing bad and hurtful facts and themes before the other side gets a chance to do this. And trial attorneys do this frequently because they know that by being the one to break this news in court to the jury, that it won't look as bad when the other side comes forward and says the same things. The same thing goes in the court of public opinion. It is an effective tool for defense attorneys and their clients to go to the media ahead of the plaintiff's attorneys or prosecutors in a case and tell the world and the media that they expect the defense attorney and their client expect to be on the receiving end of a criminal indictment or a civil lawsuit. By doing this, the defense attorney and the client can reframe the case in a way that sets the stage and sets the course for the case in a way that they couldn't normally do if they were playing catch-up. So for example, a criminal case could be framed as prosecutors run amok or a prosecution that is clearly politically motivated. On the flip side, a civil case could be positioned as maybe a business partner who has sour grapes, or maybe an example of plaintiffs' attorneys and their clients seeking a quick money grab at the expense of this well-liked defendant. By going to the court of public opinion first and framing the case in the way that's most favorable to the defense attorney and the client, the defense attorney and the client are completely flipping the script and making the plaintiffs' attorneys and the prosecutors have to almost, when they announce whatever legal dispute that they are filing, they almost have to now counter what's already been established as the framework and as the positioning that the defense were able to do by virtue of being first to the media and first to the public. If an attorney and a client want to pursue this preemptive strike strategy, there are a couple caveats they should keep in mind. First, timing is absolutely everything. When it comes to going to the media ahead of an expected legal dispute or legal proceeding to be filed against a client, The attorney and the client need to make sure that they are beating the prosecutors and the plaintiff's attorneys to the punch, but they're not doing it so far in advance that either the other side decides not to file something, or the other side has enough time to rebut what the defense is saying publicly through the prosecution or the plaintiff's attorney's own public statements and court documents. Second, not every case is going to be ripe for this kind of preemptive strike, because in order to pull it off, as I alluded to at the timing, the attorney and the client have to know that a document is coming. They have to know a legal proceeding is coming. So if a prosecutor or a plaintiff's attorney says, hey, look, on Thursday morning, we're filing this, come hell or high water, that's great for this strategy, because then the attorney and the client know Wednesday night, we're going to the media and we're announcing that we are going to be the subject of this lawsuit, and here's our position, here's our statement. A third caveat is that this is a little bit of a tricky subject. I've alluded to the idea of the timing having to be exact. I've alluded to the fact that you have to know what the other side's move is. But it's also tricky because you're going to the media, and you're going to the media kind of without a safety net. You are going to explain the wrongdoing that's alleged against you. This is important to pull off successfully, because if the media and the public doesn't understand why they should view the proceeding as wrong and inappropriate and improper, then they won't support the defense attorney and the client. For that reason, this is the kind of outreach campaign where I think an attorney and a client really need to work with someone who understands the media, understands media messaging, because if they don't get this right, there is a potential for them to have enormous egg on their face and really set themselves up to be behind the eight ball for the rest of the time that the legal dispute is pending, both from the legal perspective because they didn't explain it well, and from a court of public opinion perspective because they didn't explain it well in a way that was able to get people in the media, in the public, on the defense attorney side and the client side. These preemptive strikes are not going to be appropriate in all legal disputes, but in the right legal disputes, they are highly effective tools that defense attorneys and their clients can use to flip the script in the court of public opinion and to take control of the narrative of the legal claim or claims that are going to be filed against the clients. It is rare for defense attorneys to be able to control the court of public opinion, to be able to control the narrative, and to put plaintiffs' attorneys and prosecutors on the defensive. Preemptive strikes are one of those rare tools that allow defense attorneys and their clients to do just that.